Court of Appeals, which is the business of the people of the state of Tennessee. Mr. Hibner and the IT people for the AOC have done a wonderful job of getting this set and working, and we hopefully have worked out just about all the technical problems. But if we should have some situation, don't worry about it. We'll just pause and work through it. Mr. Hibner, if you would call the case, please.
Re Rosylyn W.
We'll hear from the appellant.
Yes, Your Honor. Thank you. May it please the court. I'm William Phillips of Phillips and Hale in Hawkins County, Tennessee. I represent the appellant mother in this matter. Mr. Francisco, Kingsport Bar, represents the appellant father. Considering that there are two of us, I'll take the first 6 minutes if it pleases the court. Mr. Francisco will take the next 6 minutes, and we'll reserve 3 minutes for rebuttal.
That'll be fine. Go ahead.
With permission of the court, and considering how little time we have in these 6 minutes, I'd like to begin my argument a bit unconventionally and start with the second prong of the termination proceeding with regard to the court's determination regarding best interest and its subsequent order directing the parties to enter into a post-adoption contract. I certainly hope to get to the grounds, but I wanted to address this first, as I think our brief has adequately addressed those. In its memorandum of opinion, the trial court purports to conclude that the termination of the parental rights is in the best interest of the child, but the trial court did not end it there. The trial court ordered that the parties into, quote, a pre-adoption contract pursuant to statute, which would provide for a continuation in the relationship with the child and both birth parents. The court finds and believes that this part of its order is very much in the best interest of the subject minor child. And as I included in the brief, and I'm sure the court, of course, the court is well aware of, terminating, quote, terminating a biological parent's rights obliterates the parent-child relationship and, in the eyes of the law, relegates a biological parent to the role of a stranger to his or her child. We simply submit that the court's finding that a continued relationship with the child is contrary to the court's determination that termination of the child's rights, or the parent's rights, excuse me, is in the best interest of the child. If it is very much in the child's best interest to continue her relationship with both parents, it simply cannot be in the child's best interest to relegate those parents to the role of complete strangers, regardless of the other stuff.
Why are the two necessarily inconsistent?
I think they are, because what the court is saying is very much in the child's best interest to maintain a relationship, to maintain regular visitation with these parents. That's what the court had directed the parties to contract. So I think that that's anathema to saying, no, we want these parents to be strangers. We want them to be obliterated, essentially, from the children's lives. So I think, regardless of the other 9 factors that the court is to consider, or the court's required to consider regarding the best interest of the child, if the court fundamentally says, and here, the trial court explicitly states it believes it's in the child's best interest to remain in the custody of the petitioners while maintaining regular contact with the parents. Well, if the court wish to do that, there are other mechanisms by which to accomplish exactly that. The court could have remanded the issue to juvenile court. The court could have instituted a permanent guardianship. There are other ways by which the court could have ensured that the children would have remained with the petitioners in this cause while still maintaining contact with the birth parents.
What is the significance then of the statute with regard to post-adoption contracts?
Yes, Your Honor. And I think that this is actually a situation where the appellant and the appellees are going to be in agreement. I don't think the statute provides the court the authority to direct the parties to enter into what the statute calls a voluntary contract. In fact, the appellants and appellees made compelling cases, I think, in both briefs regarding the court's authority to do that. The contract and the court doesn't explicitly, in its opinion, reference, excuse me, I've got the statute in front of me. it doesn't explicitly, reference 36(1)(145), but it does reference a new law passed by the legislature. So it appears that that's what the court is intending to reference.
Was this included in any of the pleadings in the case, this statute?
It was not, Your Honor.
Was there any evidence with regard to post-adoption contract during the trial on the merits?
No, sir, not with regard to the meeting of a mind between the parties. There was some testimony elicited from one of the petitioners that she intended for the parents to continue to have contact, but that wouldn't, I don't think, that wouldn't be a voluntary entering of the contract, a meeting of the minds, whereas the court's directing them to do that based upon that petitioner's testimony. The court says, I believe in its memorandum, that it intends to hold the petitioners to their word to allow the parties to have post-adoption contact, and then directs them to enter into that contract pursuant to that statute. The statute, I don't think, provides the court jurisdiction to direct the parties to enter into a, quote, voluntary contract. And I've been unable to find any other statutory authority that would allow the court to do that. In fact, it was specifically prohibited by statute prior to the 2019 amendment, I believe. So while that might be nice if the court had that as an option, I also think that it would be contrary to the public policy of the state of Tennessee for the court to continue to order people to have contact after adoption. Essentially, what a court does with a petitioner is it grants a petitioner that's successful all the rights, responsibilities, and liberty protections that a biological parent has, and then immediately would infringe upon those without proper cause.
Thank you. We'll hear from the attorney for the father.
Good afternoon, Your Honors. May it please the court, as Mr. Phillips said, I represent appellant father Scott Worley, and I would like, if I may, to focus my argument on the Supreme Court decision in the adoption of AMH and the Middle Section Court of Appeals decision in the Shelby case. As the court is aware, prior to the filing of the termination petition in this case, father had filed in the juvenile court for Hawkins County a petition to reestablish his custody rights to this child, and that case was pending and actually was set for trial just a few days after the petitioners herein filed their petition to terminate rights. I would suggest to the court that those cases are controlling, and I think if Your Honor looks at the colloquy between counsel and the court regarding the Rule 41 motion at the close of the petitioner's proof, the court appeared familiar, and although I couldn't remember the cases, I was aware that the courts had held that a pending petition to enforce a parent's rights is wholly inconsistent with a theory of abandonment of those rights by the parents.
Even abandonment by failure to support?
I believe so, if Your Honor, please. And I think the Shelby case referenced that. And if Your Honor, those cases tend to be cases involving one parent against the other and the termination for a step-parent adoption. But in this case, the father was actually petitioning for custody, not just for visitation rights. And so custody in and of itself obviously involves the support of the child. And so it's our position that he was intending and he was expressing his intention to raise his child, to support his child, and to care for his child in any way, just like any other parent would. So we believe that the Shelby case allows the court and finds that in any abandonment issue, whether it be visitation or support, that it's inconsistent with that and the express intention of the parent. And I think the cases are clear that the actions of the parent are significantly more important with respect to their intent than is prior activity. I would also point out to the court that prior to the custody petition, there's a lot of unrebutted testimony about this child spending a great deal of her time with the grandmother and the father visiting, telephone calling, and supporting both financially and in kind through the grandmother. And in fact, the gift that was given to the child during the pendency or during the 4 months, the relevant 4 months prior to the petition being filed, there was a significant gift given, and it came through the grandmother, which was a function of the normal course of these parties.
Kind of hard to use that gift for buying food and clothes for the child, isn't it?
Well, it certainly is, Your Honor, and obviously I didn't start with that argument because it's not my best one, but
Yes.
but it still is a substantial monetary gift. It's more than, if Your Honor will look at the record, the petitioner never claimed father didn't support until he moved to Georgia, and he would pay her $40, $50, $60 at a time. This $300 gift would constitute several of those payments as far as the monetary value. And so we believe that is an in-kind support, and it corroborates the father's testimony that he had during the entirety of this custody situation been supporting the child through the grandmother. And I think it's unrebutted how much time, and the petitioner basically said she knew nothing about the support coming through the mother, but it was clearly testified to and unrebutted by the father that he had done that consistently throughout the period. And the court will also note.
Well, excuse me, he didn't do it during the 4 months, though, did he?
Well, I think
Other than the gift.
other than the gift, except that if you look at the timeline that's reflected in the testimony, father filed his petition about 2 months or a month and a half before the termination petition was filed. The testimony is pretty clear that the change that occurred, we think, in retaliation on the custody petition occurred after the 4 months would have started. And father's testimony was that during the entirety of the time that the child was spending the majority of her time with the grandmother, he visited with her, he talked to her on the phone, and he sent in-kind support through the grandmother. And again, that was never rebutted.
Well, I mean, the trial court didn't find abandonment by failure to visit as to the father, did he?
No, the court dismissed that allegation.
So we're talking about on the abandonment as to father, the failure to support. And make sure I understand that your position that the father's filing the petition, attempt to regain custody, satisfies his burden to show that his failure to support wasn't willful?
Yes, sir, and that's because seeking custody inherently requires you to support the child. So he was seeking to establish the support obligation, which he had done voluntarily through the sister many times before, and she had actually gotten angry when he suggested that. Thank you, Your Honor.
Thank you. The appellants have their time for rebuttal. We'll hear from the appellee.
May it please the court. I am Thomas Levier. I am counsel for Megan D. and Michael D., who were the custodians and the petitioners in the case below. When the petition was filed, it was filed based on 3 separate grounds to terminate the rights of the parents. 1, failure to support for a period of 4 months prior to the filing of the petition. 2, failure to visit. And 3, that there was that the parents had failed to manifest an ability and a willingness to assume custody of the minor child. At the time of the trial of this case, the child had been in the custody of these custodians for a period of 4 years. The proof at trial was abundantly clear and without contradiction that neither parent made any support payment during the 4 months prior to the filing of the petition, the 4-month period. There was no contradictory testimony that sets forth any payments. Now, the father did indeed, as counsel had mentioned, did indeed indicate that he had bought a $300 gift for the child, a birthday gift for the child during that 4-month period of time. We say that is not support, or at a bare minimum is token support. That is something that while it is good that you buy a gift for your child, it does not in any way provide for the necessities for the child. It doesn't provide for food, for shelter, for transportation, things that a child needs on a daily basis. So it's certainly our position that that no payments of child support during that 4-month period by the father is in and of itself, by itself, grounds for termination of his parental rights. There was statement by counsel that the father had made payments previously, and the testimony at trial was there had been a few payments from the father, but the testimony, and as I recall, the undisputed testimony at trial, was the last payment that was made by the father was a $60 payment that had been made to the custodian in the summer of 2016, and after that, there was nothing. The mother's testimony in relation to child support was that she had provided some necessities over time. She claimed that she had provided some groceries, that she had provided some clothing. The custodian, Megan D., testified that she got none of those things during the 4-month period prior to the filing of the petition. She didn't receive any money from the mother. She didn't receive any in-kind payments from the mother, and that was clear. Now, the mother has now tried to argue both in the trial court and in front of this court that she did make these in-kind payments. But if you look at the testimony, number one, it's very vague what she did. She basically says, I provided some clothing, I provided some groceries. But more importantly is the time frame. She admits that she does not know that she did any of this during the 4-month period prior to the filing of the petition. She says she doesn't recall when she provided groceries. She doesn't recall when she provided clothing for the child. And so there is no proof in the record that any of this occurred within the 4-month period of time. So we say that there is clear and convincing evidence of grounds for termination based upon a failure to support, as well as the other grounds. I do want to address briefly the father's argument that the fact that he had filed a petition for custody, it automatically shows that he's attempting to establish his rights as a custodian, and that entirely eliminates grounds related to visitation or related to child support, a failure to support either one. And we don't believe that's what the courts in the cases that they cite mean. We think it's a factor that the trial court could take into consideration. The fact that the father had filed a petition is a factor that the trial court could look at in determining whether the father had abandoned his rights. However, it's still abundantly clear that the father did not pay any child support during that 4-month period of time. And even though the trial court dismissed this after the petitioner's proof, it's abundantly clear that he didn't visit during that 4-month period of time. He had the right to visit. There was an order that said he had the right to have daytime visits. The custodian, Megan D., testified that she had arranged for him to come visit the child in the state of Tennessee in the month of June of that particular year, and the father didn't come, and he filed his petition in July. So what we're saying is the trial court should have considered it as a factor, but only in the context of, even after the petition was filed, the father still did not ask for visitation with the child, and he didn't pay any child support. If he was seeking to establish his rights, what he should have done is immediately asked to see the child, which he did not do, and immediately begin paying child support for the child, which he did not do.
Counsel, so am I correct? The father, I think that's what you just said, that after he filed his petition to regain custody and before the petition to terminate was filed, he made no payments or contribution to support during that time.
That's
except
correct.
for perhaps the gift we talked about.
That's absolutely correct. And even up to the trial of the case, which was almost a year later, the father still had not made any child support payments. And I understand that that's not the time period that we're looking at. But if the father was truly seeking to establish his rights, that's something that he should have immediately started doing, is jumping in and paying some amounts towards the child support for the child. And in case it's not clear, I do want to state this. The father had a very good job. He testified that he had a very good job with a Fortune 500 company. He was making $19.04 an hour. He was working 40 hours per week. There's no reason in reality that he could not have been paying some amount for support. He attempted to establish at trial that he had other obligations. He said that he had a rent payment that he had to pay to the lady that later on became his wife. When she testified, she said it wasn't a rent payment; he paid the utilities. But that's kind of neither here nor there. The testimony is clear that the father made no payments towards the child support of the child, and didn't visit. And just to let the court know, we do believe the trial court was in error in dismissing the grounds of failure to visit by the father. That the only thing that the trial court, the only reason the trial court dismissed that particular cause of action was the simple fact that the father had filed his petition seeking to establish rights to see the child or rights to custody. So our position is that is not sufficient. The filing of that petition is not sufficient enough that the evidence of grounds for termination of the parental rights of both the father and the mother. I do want to address the other issues because it's a little bit of an unusual argument. As I understand it, counsel for the mother is arguing that the fact that the trial court referenced this post-adoption contract, potential post-adoption contract, and stated that it was in the best interest of the child, negates the finding made, or the finding by clear and convincing evidence by the trial court that termination of parental rights was in the best interest of the child. And I'll say this: what the trial court did was very unusual. It was something that wasn't requested by any of the parties, to my knowledge. But when the trial court did it, and in the memorandum opinion of the trial court said two things. The first thing the trial court said was referencing the best, and this happened immediately after the best interest analysis, mentioned the continuation of the relationship with both parents, and stated that that it was appropriate, and this is the court's language, so long as the petitioners after adoption can raise this child without unwelcome interference from the birth parents. So in other words, what the trial court was saying there was these petitioners should have the right to make decisions as to these children without having any interference with the birth parents, from the birth parents. So what the trial court was saying was not that, it's necessary that this child have continued contact, but one, as counsel stated, we think it's important, the trial court felt it was important to hold the petitioner to her word that she was going to allow that contact. But then two, the trial court referenced the findings of the legislature of the state of Tennessee and said that the legislature has recently recognized that in many cases it is not only permissible but encouraged that an adoptive child's relationship with various relatives should survive the adoption. So while the trial court did do something very unusual there, it does not trump the finding of the trial court that the termination of the parental rights is in the best interest of this child by a clear and convincing standard. We do agree with counsel, and we briefed this issue. There's no case law on it to my knowledge, but it is our position that the trial court did not have the authority to mandate that the parties enter into a post-adoption contract. I think the language of the statute is very clear that it's something that that parents can do voluntarily, but we think it was improper and the court did not have the authority to make that a mandatory requirement related to the adoption. So we think that at least in that one regard, the trial court should be reversed. I do want to touch briefly on the best interest analysis because the trial court did do a thorough and substantial job of addressing the best interest of the child. And he looked at every factor of the statute and addressed every factor of the statute and made a finding in relation to every factor under the statute as to each parent. And the trial court did not find that every factor weighed in favor of termination, but as the trial court was required to do, did a balancing act and looked at all of the factors and said that overall it was there was clear and convincing evidence that the parental rights of both parents should be terminated due to these particular factors. One thing that I think is very important is the testimony of the mother that relates to her ability to provide care for this child. The mother clearly testified that she wasn't able to do so. This is 4 years after the child had gone into or left her custody. And the mother acknowledged that this child recognizes the custodian as her mother figure. The mother recognized that she did not have the ability to provide care and wasn't in a position to provide care for the child in the future. She just didn't want her parental rights terminated, and that's probably a natural reaction. But she did admit that she did not have the ability to care for this child. She admitted that the child was well adjusted in the current placement. The mother admitted that the child refers to the two custodians as mommy and daddy, that she's very happy there, that she loves her family. There are 3 other children in the household, and the mother testified that her child, Rosalind, had bonded with the other children in the household. And for all of these reasons, we think that the testimony is abundantly clear that it is in the best interest of Rosalind that the parental rights of the parents be terminated. And we think the court there's grounds by clear and convincing evidence to terminate for failure to support. We think there's also grounds in relation to the father to terminate for failure to visit. And it's in the best interest of the minor child that the parental rights be terminated.
Thank you. We'll hear from the appellant rebuttal. Y'all divided was it 3 minutes?
I believe I was going to take the 3 minutes, Your Honor.
That'll be fine.
With regard to the mother's testimony, I'm not sure that that's entirely accurate within the context of the mother's testimony. But I have noticed this as a pattern in termination proceedings these days. A parent gets on the stand and they're essentially put in a catch-22 because they're often asked, how has your child fared with the current custodian? And when they're appropriately appreciative, when they say, I'm grateful that they were there, that they stepped in and were able to provide good care for my child when I couldn't, and that when that's an honest answer, I'm finding that it's subsequently being used against them, but that's simply a general observation. Counsel was correct when he noted that the court said that he wished the petitioners to be able to raise the child without unwelcome interference from the birth parents. Again, the court could have accomplished this in any other way, through a permanent guardianship, for instance. When the court says unequivocally that it is very much in the best interest of the subject minor child to maintain a relationship with the birth parents, I think that that is absolutely anathema to concluding that termination is in the best interest of the child. There are the 9 factors, and counsel mentioned that we had to weigh these 9 factors. We do, but we don't weigh them as if 5 are in support of termination and 4 aren't, then we terminate. any one factor can dictate the trial court's conclusion or judgment on that. Very, very quickly, with regard to child support and the mother, we would, of course, as we submitted in our brief, that any failure to pay was not willful. My new favorite legal phrase is that we must consider the constellation of the facts in this matter. I know that your honors have asked about the 4-month period, but when considering willfulness and the constellation of facts that compose willfulness, we can look outside that 4-month period. In Re Caleb NF, which we cited extensively, the court notes the failure of foster parents to ask for monetary support coupled with their rebuff of mother's inquiry about specific items needed are part of the constellation of facts that must be considered to assess willfulness. Moreover, even if mother's provision of in-kind support had become sporadic during the 4-month period preceding the filing of the termination petition, the fact that mother had previously bought such items to her visits brought may be considered as part of the background of the willfulness determination. Here, I think the same with the father as well. The petitioners did not ask for support. The petitioners rebuffed mother and father when they asked regarding specific items that the child might need for support. It was undisputed that mother provided in-kind support through gifts, clothes, and meals. And the mother was, she was never ordered to pay support. Thank you.
Excuse me. Thanks to all counsel. I believe we understand the issues and your positions. You would, Mr. Hibner, recess court until 2:30, please.
It's honorable.